This is an orientation to California state government, primarily for Lobby Day attendees. So, what should your Lobby Day participants know about California government before they embark on that Lobby Day at California State Capitol in Sacramento? I try to set forth some of the key items for them to get acquainted with regarding the legislature as well as the California legislative process. So, to begin with, the branches of state government. Like its federal counterpart, California has three branches of government: the legislature, comprised of the Senate and Assembly, executive, headed by the governor and the other eight constitutional offices, and the judicial, headed by the Supreme Court. The three branches of government are set forth in Articles 4, 5, and 6 of the California State Constitution. We also have, like the federal government, a hierarchy of laws. So California has the following bodies of law in this order of priority: Constitution, adopted by the people; statutes, the laws enacted by the legislature or voters by initiative; regulations, regulations adopted by executive branch entities like departments and boards or commissions; and the common law, the appellate court decisions issued by the judicial branch. Where do we find California rules for the legislative process? In this order, the following are the sources. First, the Constitution, then the Government Code, the Joint Rules, the House Rules, individual committee rules, Mason's Manual, and finally the customs and practices of the individual houses. What does lawmaking in California look like as a practical matter? Well, first, a quote from Article 4, Section 8B1. The legislature may make no law except by statute and may enact no statute except by bill. So the legislature is granted the lawmaking power in the Constitution along with the people, and they can only make law by bills, which become statutes. They do consider constitutional amendments that they can place on the ballot for a vote of the people. And they also consider three types of resolutions: House, concurrent, and joint. But resolutions don't create any laws in California. So, in looking at the past 33 years, 1993 to 2025, the legislature has averaged 2,456 annual bill introductions, 1,547 of which are assembly bills, and 909 of which are Senate bills. Of those, about 1,105 introduced bills reach the governor's desk each year, about 45% of the total. 911 of those bills on average get signed into law, 82.4%. And on average, 194 bills get vetoed, 17.6%. Note that there's also lawmaking by the people. In Article 2 of the state constitution, the people can amend the Constitution but not revise it. And they can enact statutes. In either of these cases, they do so by initiative, which of course the statewide electorate must approve. First, the legislature is an institution. Briefly, like the federal Congress, the California legislature is bicameral, meaning it has two houses. It's comprised of the 80-member assembly, each of whom serves for 2-year terms, and the 40-member Senate, each of whom serves 4-year terms. The legislature, like Congress, operates on a 2-year session. Legislators are subject to term limits, which is a lifetime maximum of 12 years in either house or a combination of service in the two houses. The leaders of the respective houses, Speaker of the Assembly, and President pro tempore of the Senate. Yes, the lieutenant governor is the president of the Senate, but the pro tem is the day-to-day leader of the Senate. Also, legislators are prohibited from accepting any honorarium. They're limited in receiving gifts, and they are bound by strict conflict of interest laws. There's also a 1-year revolving door prohibition for legislators becoming paid lobbyists. So let's turn now to an overview of the California legislative process. Unlike the federal Congress, the California legislative process is dictated by its adopted calendar. Although there are some exceptions, the vast majority of legislation is considered and voted on based upon that announced calendar. To begin, a bill idea can come from any source: individuals, interest groups, legislators themselves. The attorneys in the Office of Legislative Counsel draft all the bills and amendments, even if an outside group or lawyer initially drafted the proposed bill language. A legislator decides whether to author a bill after considering the bill idea. Those bringing forth a bill idea are expected to put together appropriate information and materials to make the case for the bill's introduction and its ultimate passage through the legislative process. The introduction of a bill by an assembly member, an assembly bill or AB, or by a senator, a Senate bill or SB, officially starts the legislative process in California. Bills must be introduced by the specified deadline, which is usually the third Friday in February. A bill goes through 3 official readings pursuant to our state constitution. The first reading occurs when the bill is introduced in its house of origin. It's given a bill number by either the Assembly Chief Clerk for an AB or the Senate Secretary for an SB, depending, of course, on in which house the bill is actually introduced. A bill cannot be acted upon for the next 30 days under the Constitution. This gives interested persons adequate time to review the contents of the bill and begin to weigh in with their support or opposition. After that waiting period, a bill is referred to one or more policy committees by the respective Rules Committee of either the Senate or the Assembly, depending upon which house the bill was introduced in. Now, one or more policy committees will consider the policy aspects of a bill, first in the House of Origin. Committee staff analyze and write analyses that are made publicly available and used by legislators, staff, lobbyists, and the general public, as well as the judiciary, to understand the bill's implications. In at least 3/4 of all the bills introduced, there's also a fiscal review, where the respective fiscal committee, which we call the Appropriations Committee, assesses the bill's fiscal impact. Currently, there are 32 Assembly Standing Committees and 23 Senate Standing Committees for the 25-26 legislative session. They'll hear all of these bills. Each of these committees have a chair from the majority party and a vice chair from the minority party. Small committees may range in size from 5 to 9 members, while larger committees can reach 19 to 30 members each. During the committee hearing itself, the bill author presents the bill to the committee, and then usually 2 support witnesses and 2 opposition witnesses present the substantive testimony for and against the bill. Others often give "Me Too" testimony. These witnesses, in support or opposition, simply identify themselves by stating their name, affiliation, and whether they support or oppose the bill. Thereafter, the committee may debate or discuss the bill before proceeding to a vote on the measure by passing the bill as amended, or defeating the bill. In addition to the brief testimony provided at the committee hearing, so long as they are received in advance, usually at least a week or more, letters or other written materials submitted will also be considered by the committee and may in fact be reflected in the committee staff's analysis of the bill. Each house maintains a schedule of legislative committee hearings that are contained in the Assembly Daily File and the Senate Daily File, as well as on the committee websites, which are found on the respective Assembly and Senate websites. The Assembly is www.assembly.ca.gov, while the Senate is www.senate.ca.gov. Prior to the bill's hearing, a bill analysis, as mentioned, is prepared. It explains generally current law, what the bill proposes to do, and additional background information to assist readers, but also ultimately legislators who cast their vote. Typically, this analysis also lists organizations and individuals that support or oppose the particular bill. Once committees have concluded their role, then a bill goes to the floor in its house of origin. Bills passed by a committee are read a second time, and then for the third time, which commences the floor debate and discussion, followed by a vote on the bill. Now, most bills in the legislature require a simple majority to pass either floor, which of course is 41 votes in the Assembly, 80 members, and 21 votes out of the 40 members in the Senate. Now, there are some bills, such as urgency clause measures, that require a supermajority vote in order to pass either floor. If the bill passes its house of origin, then the process repeats itself in the other, which we sometimes call second house, and it goes through the same committee and floor processes there. If a bill is amended in that second house, no matter how much or how little, the bill must return to its house of origin for a final concurrence vote, which means a vote by the original house, whether its members agree to the other house's amendments. That's the purpose of the concurrence vote. Assuming a bill passes both houses, then the governor is given an opportunity to weigh in with either a signature or a veto. Now, officially, the governor has three actions. The governor can sign a bill into law, can veto it, or allow it to become law without a signature, a pocket signature rule. But this is a process which most governors rarely use. Now, a veto can be overridden by a two-thirds vote of both houses. Most bills go into effect on the first day of January of the year following enactment. However, urgency measures, budget bills, among others, take effect immediately after they're signed. Finally, in collaboration with the governor's office, the Secretary of State assigns an enacted bill a chapter number. And that bill then takes its place in one or more of the 29 codes that contain almost all of California's 156,000 codified statutes.